Hello everyone. Today we are going to present Business and Corporation Law. My name is Kyung-Im Choi and our group members are Mohammed and Kasol and then Katika. Our case is HI6027 versus Citigroup. This is the issue of this case. There are two issues for Citigroup act in contravention of their fiduciary duties to toll by sharing information between dividends in the bank to trade on. The second issue was whether they are trading officer engaging in insider trading by buying shares in Toll's takeover target Patrick the day before the announcement. Citigroup was engaged by Toll as the joint advisor in the proposed takeover of Patrick, even though according to HI6027, Citigroup were acting in the provision of financial services. The letter of engagement states that Citigroup had been retained solely as an advisor to Toll as an independent contractor and not in any other capacity, including as a fiduciary. The Citigroup trader, after receiving an instruction by his superior not to buy any more Patrick shares, constitute inside information, even though his superior did not explicitly state the reason for the trader to stop buying Patrick stocks was the bank was advising Toll on the takeover of Patrick, which was due to be announced the next day. The trader testified the reason he understood to have been told to stop buying Patrick's share was because he had too much risk on his trading book. Therefore, he then sold some of his position off.
So there are some rules regarding the issues mentioned before. The first one is comes from section 181 of Corporation Act, which says it is a civil obligation on directors, secretaries and other officers of a corporation exercising their power and discharge their duties in good faith, and under section 184 the breach of this duty will be a criminal offense. And section 180 of Corporation Act says that it imposes a civil obligation that a director must all the time take a reasonable degree of care in the exercise of power and discharge of their duties. Section 182 of Corporation Act says that prohibits a director or other employee for making improper use of their position for certain advantages. Section 184 of Corporation Act says that it is an offense if people use their position dishonestly. And also section 191 of Corporation Act says that the duty to disclose certain interest. Now the rules the application regarding all the rules are being described by one of my other friends.
His application, HI6027 versus Citigroup Markets 2007, encompassed two areas that are significant. Firstly, whether there exists a fiduciary duty or relationship to Toll by using the information from one part an investment bank to another division in order to trade on. Secondly, the question of liability for insider trading and the equity of the information barriers or Chinese word that can be used upon individual interest. Citigroup Global Market Australia conducted its business through two divisions, including investment banking and equities trading. For this reason, Citigroup set up Chinese walls prevent the information sharing within business dividends. When equities trading dividends proposed shares in Patrick Corporation during the time when investment banking dividends was acting for Toll Holdings, there was a conflict. There was a proposal of takeover bid for Patrick, and this event implicitly exposed information. 200,000 shares were purchased on the last trading day before the announcement of Toll for Patrick Corporation's bid. Once aware of this, investment banking took corrective measures which led equity trading to stop further purchase of Patrick shares. However, equity trading then sold the shares it held for a profit, leading Toll to postpone its announcement of takeover bid for Patrick.
For the next one, alerts in Section 193A of Corporation Act 2001, Citigroup breach in the fiduciary duty, and under Section 1043H of the Act and Section 12DA of the ASIC Act, Citigroup breached the fiduciary claim with the assault of the misleading conduct. The verdict stated that the letter of engagement said bond to Toll Holding and the Citigroup executed continuations of the fiduciary relationship in relate to the equity trade. Under the Section 1042A of the Corporate Act, for the first inside trading claim to accomplish, the employee who make the trade has to have a knowledge, ability, attributable to Citigroup. The court held that the officer for the intent of act should have the significant role as the senior manager, which in this case of employee was not. According to Section 1043F, Citigroup held the court's decision in its favor by demonstrating that comprehensive arrangements were in place that could reasonably ensure information held in IB and was not continued to the ET. To conclude the case of the ASIC vs. Citigroup Global Market Australian Party 2007, Federal Court of Australia was dismissed all the ground and caused award against it. Because the first one, the ASIC the ASIC alert the Citigroup breach the obligations as the financial service licensee to manage its conflict of interest. It's under Section 913A of the Corporation Act 2001. However, the court found that the relationship between both parties about the Citigroup and Toll was not fiduciary in character according to the man-made letter. The man-made letter provided that Citigroup was to act as independent conductor to and not in any capacity including as a fiduciary. Second one, the ASIC alert that Citigroup breach in the inside trading provide in Section 1043A of the Corporation Act. ASIC alert that there is conversation between private and public side of employee about the subject of buy and sell the Patrick share. However, the court found that trader was not a Citigroup officer and trader knowledge of the proprietary trader not being contribute to Citigroup. Citigroup had adequate Chinese wall in place as required as Corporation Act. Thank you for listening.